Thank you, Shafat for that very interesting introduction. Thank you, everyone, for attending this session. We had extremely stiff competition from arbitration. I'm delighted to be on the same stage as this illustrious panel. If I was in the audience, I would actually rather listen to them more, and I hope that this presentation ends very quickly. This presentation that I have, it's a short one. I hope it ends in 10 to 15 minutes. I want to give an overview of the banking sector, a snippet, an overview of the legal framework around it, and a couple of recent legal developments. There has been a lot of legal developments recently, and I hope the panelists will also enlighten us with those. I just hope to open the discussion with a little input from myself. So I am Saqeb Mahbub, as Shafat introduced. I will not waste time on introducing myself again. So the banking sector in Bangladesh. There are 57 scheduled banks in Bangladesh. They're divided into 4 categories, as Bangladesh Bank defines them. State-owned commercial banks, SCBs, like Sonali, Rupali, state-owned development financial institutions, private commercial banks like Citibank, foreign commercial banks like Standard Chartered. As you know, as we have all seen in the media, the banking sector is facing a lot of problems, and the biggest problem seems to be non-performing loans. There are large borrowers who are in default of thousands of crores. Particularly, the state-owned commercial banks have been most hard hit. The government is recapitalizing them using taxpayers' money every year. In fact, there is a statistic from the Bangladesh Bank says that 116 billion taka, so that's 11,600 crores of taka, has been injected into state banks from 2011 to 2017, and that is all taxpayers' money. There has been allegations of corruption, poor risk management, and collusions with businesses. There has been allegations that influential borrowers have impunity from banks. And when it comes to the regulators, it seems that regulators are also concerned about taking hardline measures when it comes to large borrowers, because it can destabilize the sector. This is a graph prepared by Bangladesh Bank. It shows the state of how non-performing loans have gone up recently. The blue line you will see, that is the amount of non-performing loans in state banks that has gone up. It has reached about 350 billion taka. The orange line is private commercial banks. They have not really lagged behind that much, although foreign commercial banks have done better. This graph shows the percentage of non-performing loans, which has also gone up amongst percentage of non-performing loans to total loans. So the blue line is the percentage. So as you can see, it has hit in 2017. It hit 10%. So 10% of all loans are non-performing loans. So that's the overview of the banking sector right now. And let's come to the legal framework around it. What are the laws? The laws, some of the laws here are the Bangladesh Bank Order, which established Bangladesh Bank sets out its responsibilities. The Securities and Exchange Commission Ordinance is here because most banks are listed companies, so they are also regulated by them. The Bank Companies Act is probably one of the most important. It sets out the corporate governance of banks and gives Bangladesh Bank certain powers. Then there's, for loan recovery, notable is the Orthoin Adalat Ain, which is it is a special law for recovery of loans by banks. In recent times, the Negotiable Instruments Act has become instrumental to banks in recovering loans as well through security checks, and I will elaborate on that later on. So, since we are short of time, I will not go into too much. There's also obviously many hundreds and thousands of Bangladesh Bank circulars that also form part of the banking regulation in Bangladesh. There's Securities and Exchange Commission circulars, and there's various guidelines that are meant to look after the activities of a bank. So amongst recent legal developments, the one that has got highest press coverage in recent times is the Bank Companies Amendment Act of 2018. It is a very recent amendment. Major change it makes is that the maximum number of family members in the board of a bank has been increased from 2 to 4. The number of 2 was set in the 2013 amendment. And also another requirement that was set in the 2013 amendment of the Bank Companies Act was the maximum tenure of a director. Previously there was no tenure of a maximum tenure. In 2013 it was set at 6 years. But now in 2018 that has been set to 9 years. And interestingly, it has been given effect prospectively. So which means that someone who took office in 2013, who has coming to the near to its end of the tenure, now gets another 9 years. So making it about 14 year tenure. And who knows if at the end of that tenure another amendment will come. This amendment was criticized heavily. Bangladesh Bank itself opposed the amendment. The opposition in Parliament walked out when the bill was passed. It is notable that in 2013 it was an IMF recommendation that actually influenced the government to create that restriction of 2 family members and 6 years duration. So the IMF recommendation actually has been made redundant. And there's allegations or arguments that this has the possibility of consolidating control of important banks in the hands of some families and some individuals. And there's also possibility of increased interference in management decisions, such as disbursement of loans. So I would like the panel to elaborate on that, but moving on to another, I would just give the bank side as well. The bank, obviously the Bankers Association was advocated for that change, and they argued that there's going to be higher accountability if the tenure is longer, and it would also incentivize sponsor directors to ensure good governance in the banks if they're allowed to stay on longer. I would move on to another area of law that has gotten a lot of litigation and has seen some development in the recent times, which is the jurisprudence regarding security checks. Lots of lawyers will be familiar who are acting for banks in court and who are acting for defaulters will be familiar with this jurisprudence of recent times. The context is that banks take security checks when sanctioning loans, and then when the borrower is in default, the bank goes and encashes the check, and if there is insufficient funds, which usually there is a criminal case under the Negotiable Instruments Act. It is notable that there is also usually parallel Orthoin Adalat Ain proceedings for the recovery of the same loan. So what happened in quite a few times was that there was the High Court issued rule and stay both in the writ jurisdiction and in the jurisdiction of Section 561A of the Code of Criminal Procedure. The arguments that came from the bar and were accepted were at that time a few of them was for example, that there is double recovery issue. So there is a recovery through the check, and there is also a recovery through the Orthoin suit. There was an argument that security checks cannot be encashed because there is other collateral security, for example, mortgage property. There is an argument that the banks don't have authority under the Bank Companies Act to use security checks for recovery of loans, and that the Orthoin Adalat Ain is the sole act which they should use to recover loans. However, this did not fly well, and in the end, the Appellate Division actually has settle the matter. In 17 BLC AD 177, the Appellate Division found no illegality in instituting NI Act proceedings for dishonor of security checks. The Appellate Division later reconsidered the judgment and then again held that there was no illegality in that. So security checks can, the cases for security checks can go on besides Ortho in Adalat suits. However, the latest judgment is not out yet. The findings, overarching findings of the Appellate Division has been, although this is my language, that a check is a check. There's no such thing as a security check. It doesn't have any special status. There is no bar in the law to having criminal proceedings besides civil suits or Ortho in Adalat suits. There is the cause of action for the NI Act case is the dishonor of a check, which is a criminal cause of action, whereas the cause of action for the Ortho suit is a civil cause of action. So as such, they are different. And overall, that it's not the intention of the legislature to bar NI Act proceedings for security checks. Without going into the merits of the judgment, I would just like to highlight some practical issues of what happens. What from my practice happens because of this, that banks have unfettered discretion over when to encash security checks. Theoretically, they can be encashed anytime. They can be encashed for amounts that are higher than the existing debt. This is theoretically, although practically it may not happen too often. Criminal proceedings require regular attendance in court. There's police involved, etc., and this impedes business. So it actually impedes the capacity of the business to repay the loan. If he's going to court every day, he cannot actually do business. And that the conviction under an NI Act and then the subsequent appeal does not absolve the defaulter of the liability under the Ortho in Adalat and vice versa. However, NI Act proceedings do put real pressure on the defaulters, and as such, the argument has been forwarded from the bank side that the Ortho in Adalat sometimes has weaknesses which are then covered by the pressure that is put on by the Negotiable Instrument Act proceedings. Just lastly, like to point out some weaknesses of the Ortho in Adalat which impede banks from doing effective debt recovery. For example, there is a provision for auction of mortgage property before the Ortho suit is instituted and right after at the enforcement stage, at the execution stage. However, there is no opportunity to do an auction in between. There are high numbers of writ petition against interim orders of the Ortho in Adalat. Not always these entertained, but still they create hindrance and slow down the process of the recovery. Then the enforcement mechanism that is provided in the Ortho in Adalat has some weaknesses that ultimately it depends on has to depend on the police and the administration. So say there is an arrest warrant from the court. However, the arrest warrant has to be executed by the police. So if the police doesn't comply, then the bank has nothing to do. Say the bank is trying to take possession of a mortgage property, and if the administration doesn't cooperate, then the banks have nothing to do. And it often happens that the banks are helpless in those cases. So I would not like to take any more time from the panelists. I would like to hear from them, and that is all. Thank you for listening. Thank you so much.